Welcome students to this video series on incorporation. Business associations begins with the meaning of business, but businesses themselves begin with the incorporation process, which is what we're going to talk about in the next series of videos about how to actually start a new business venture in the form of a corporation. In this video series, we're going to cover 3 topics involving incorporation. The first being incorporating a Delaware corporation and some of the decisions involved in whether or not to incorporate in Delaware or elsewhere, and then the process of how to go through that. 2, defining corporate powers. There's a doctrine called the ultra vires doctrine, which states that if a corporation acts outside of its corporate powers, that action is unlawful. We're going to try to avoid that. And third, speaking of lawful activity, as lawyers, we need to think about legal ethics. Legal ethics come into play in incorporation in some unusual ways because we're representing a situation, not necessarily any individual people, although they may think we represent them. So we're also going to need to delve into some of the legal ethics of incorporation to really understand the lawyer's role in this process. We're going to begin by looking at the process of incorporation in the state of Delaware. But as a preliminary note, why Delaware? Why would we choose Delaware as our state of incorporation? And then once we've established why you may or may not, let's talk about the formal requirements there. They do vary state to state, but Delaware is a typical state and a big one for corporations, so it makes sense to start there. And we're also going to talk in this video series about the ethics of doing this with regards to having multiple parties. So we'll come back to that in a subsequent video. But in the process of incorporation, you may be asked to represent 2 or more persons plus a business. So how do you deal with that as an attorney? We'll cover all of that. Which state should you incorporate in? Remember, you can incorporate in any state you want. Now, why would you even care? Why would it matter? Well, the state of incorporation is the state that will guide your internal affairs. So the internal affairs doctrine is a law which basically says that the internal affairs of a corporation are governed by the laws of the state of its incorporation. Internal affairs regard matters between corporate constituents like directors and shareholders. So think about shareholder lawsuits. So if the shareholders want to sue the directors for breach of fiduciary duty, they would do so according to the laws of the state of incorporation. Now, this doesn't pertain to things like minimum wage. So it's not like you can incorporate in Wyoming and do business in California and pay a lower minimum wage. That's not an internal affair. That's an external affair. That's not just regarding corporate constituents, but the corporation and someone else. So you want to look at the various state choices, which are going to have the best laws governing the internal affairs of the corporation, because you get to make that choice. And you might pick your home state, because at least in your home state, you have access to the local courts pretty easily. And for small businesses, this may be a perfectly adequate situation. Plus, there's some costs associated with making a choice like Delaware. Now, Delaware is important because most of the Fortune 500 and many of the companies listed on the NASDAQ and NYSE, New York Stock Exchange, are listed, are incorporated in Delaware. But if you're not going to go that big, it may not be necessary to incorporate there. There are some costs, but the law is very certain because there's all these major companies there, and there's a lot of attention in Delaware to corporate law. And they have a court of chancellery, which specializes in getting corporate law issues right. So there's some good reasons to choose that if you think there might be litigation. And there may be other reasons to choose another state that is not your home state and is not Delaware, depending on your various needs. So let's talk about why Delaware and why not, because that's what most people are deciding between, the home state or Delaware. Home state, you get some cost benefit. Delaware, you get some, well, what do you get? So why Delaware? Companies that plan to operate nationally or internationally and require outside investment generally select to invest in Delaware because Delaware tends to protect managers. And the managers are going to make this decision. And as the managers want to protect themselves from shareholders who might otherwise sue them, and for that matter, shareholders may want this too. Shareholders don't necessarily want directors to be sued easily because that can distract them from their duties and can cause them to be more cautious. So investors are generally comfortable that Delaware's corporate governance, internal affairs doctrine are reasonable and get good results. Plus, there's a specialized court to deal with things there. So, given the comfort level of investors, Delaware is a good choice if you are going to have investors, outside investors. On the other hand, if you're not going to have outside investors, but you're just going to do business in your state, it may make sense to incorporate in your home state. It's almost always cheaper to incorporate in your home state, and it's almost always simpler because you don't have to go through additional registration procedures. Plus, you may have more local attorneys who cost less, who are competent to represent you versus understanding Delaware law. Some states, your home state may have rules that you prefer, like anti-takeover provisions. So there are some states that make it harder for shareholders to take control of a company. Depending on whether you see yourself in the minority in the future, that may be something you prefer. And so there are certain companies that have made choices based on this. Pepsi is in North Carolina, for example, not Delaware, major corporation. But usually the choice is between either Delaware if you're going to get outside investment, you're going to have outside investors who don't know. Delaware is a neutral territory where a lot of people are comfortable. If you're going to get investors you do know, like your friends and family, locals, or not investing, not getting investors, then your home state's probably a good choice. Who can form a corporation? The incorporator forms the corporation. And this can be a lawyer. I've done this many times. So sometimes the incorporator is someone, an agent working on your behalf. This is true under both the Model Business Corporations Act and under Delaware General Corporation Law. Under the MCBA, it also holds that one or more persons may act as the incorporator or incorporators of a corporation by delivering articles of incorporation to the Secretary of State for filing. It's just whoever turns in the paperwork. But let's say we're going to associate, incorporate in Delaware. How are we going to go about doing that? Well, the first thing is to select our entity type. I have a series of videos on the topic of entity selection, which you can check out, called Organizational Choices, and that will help you decide if you want a C corporation after all. Delaware is the place to have a C corporation, but it doesn't necessarily have the best LLC laws. So you choose your entity type as well as your state of incorporation. You then simply register very basic paperwork with the Secretary of State. You obtain a employer identification number from the IRS. Delaware has a thing called One Stop where you can register for all your permits. Most states have something like this as well, where you go through a state regulatory permitting apparatus as well. And then if you are, for example, in Pennsylvania and you're registering in Delaware, you then have an additional step, which is going to cost you some money, of registering as a foreign corporation. So in this example, I'm in Pennsylvania, I'm registering a Delaware corporation. I'm going to have to pay to register the Pennsylvania entity as a foreign, rather register in Pennsylvania as a foreign entity. There's a cost associated with that. Let's talk about cost for a minute. We have to pay for all these things. The first cost is filing the certificate of incorporation, also known as the charter. It's about $90, depends year to year. There's an annual registered agent fee. See, if you're not located in Delaware physically, someone has to be there to accept your mail when you get served for process to go to court. And you need to pay that person anywhere from about $50 to $350. You'll be paying Delaware annual franchise taxes. If you have less than 5,000 shares of stock, you could potentially pay a minimum of $175. But if you have more shares of stock, or if you're operating on a larger scale, your minimum tax is $350 a year right off the bat, going straight to Delaware. And that number, of course, goes up as your revenues scale. You'll also have to include an annual report, which we'll talk about in a moment, but you have to disclose a few additional details to that. And then you're going to have to pay those foreign fees, like if you have an ongoing obligation to Pennsylvania, in the example that I gave. So it's not cheap to have a corporation year over year. I mean, this is nothing if you're Facebook, Google, Microsoft, right? But if you're Joe Schmo or Seth Orenberg and you don't make a lot of money, this is thousands of dollars potentially in a year because you have, in addition to these fees, which are close to $1,000 on their own, you also have to spend the time to get all the filings done, and you're going to have an accountant or do the accounting. So you should be looking to allocate probably $2,000 a year just for the ongoing upkeep costs of having a corporation and running it properly. Is it worth it? That depends on your use case. You can save some of this money by incorporating in your home state. Then you don't need the registered agent. The annual franchise tax fees may be lower state to state, so you can get lower taxes potentially. But it's certainly not free to have the business, and you do get benefits in terms of limited liability. Are they worth it? Depends on your use case. Once you've got your certificate of incorporation, you're going to register it with the Secretary of State. They're going to require that you have a registered agent, which means if you don't live in the state, you have to have someone who's willing to accept your mail so that you can be sued in the state. That can cost you $50 to $350 a year in an annual fee. You'll select your name and you'll file your incorporation paperwork. The certificate of incorporation you file is actually a really simple document. You just need, as a minimum, to have the name of the company. There are restrictions on what you can name a company. You can't call it a bank if it's not a bank. You can't call it a university, etc. Have to have the appropriate suffix, Inc., Corp., what have you. So there are rules it has to follow, but nothing too crazy. The address of the registered agent, remember, someone has to be in the state in which you're incorporated to accept mail, so you can be sued in the state. If you don't live in the state, you have to pay someone to do this for you. The nature of the business, which can be very broad, such as any lawful purpose, and the number and par value of authorized shares, which relates to the capitalization of the company. Now, there's a lot more you can put in a certificate, and they can be long, but typically a startup company is going to have a one-page certificate, and there's a form we're going to look at later. Very simple form, very easy to fill out. How do you choose your registered agent? I mean, in Delaware, again, one reason to choose Delaware as your outside state is that they have a robust network of people who do this, who accept service of process. There are several on their website. I go with the cheapest one because, I mean, I don't use their services for anything other than to meet the bare requirements. So that's all I'm looking for. There's some that have additional features, I'm sure, but you can find them on the Delaware website. Selecting a corporate name can be tricky. Your clients may not realize they have to have a suffix. Each state also has its own rules. You're going to want to make sure the name is not taken prematurely, so you want to do a name search. You can go to the Secretary of State website and do an entity search and see that the name is not already taken. But do search for that and then help steer your clients toward a name that is going to help improve their business prospects. There's a number of different suffixes we can and must put on a corporate name. Just take a look at your local regulations. You can look at Delaware General Corporation Law Section 102 for general guidance. And of course, if you incorporate outside of Delaware, you'll be selecting a different name based on whatever the statutory requirement is there. And last but certainly not least is your capital structure. At least in Delaware, a new company must have at least one authorized share and at least one shareholder. You cannot have a zero shareholder corporation. And as a result, you must authorize and issue a share of stock along with the inception of the company. You must have a shareholder, so you must issue some stock. So we're going to look at a stock purchase agreement, and that is one way to issue that stock. Quick note on capital structure, Delaware does not allow fractional shares, unlike units, which can be fractional, but you cannot have 0.1 shares. And as a result, that is going to have a lower limit on how many shares you can issue, how much a share can be worth, since you cannot divide them into fractions. The result of this, of course, is that you can simply issue more shares, making each share lower valued each. But Delaware will charge you tax based on how many shares you've issued. So, as I mentioned in a previous slide, the way to get the lowest tax in Delaware is to have 5,000 shares maximum. And that means that each share can be worth no less than 1/5,000th of the company. And you may want to issue a smaller increment than that at some point. So you will be incurring some additional tax there. This nature of non-fractional shares has changed corporations. Some say that Facebook went public because it had to issue too many shares and had too many shareholders and couldn't comply with private company requirements anymore. So some of these aspects can actually drive major institutional change. You, of course, are not limited to just having one share. You could authorize more shares. For example, you could give more shares to founders than just one. You could reserve some that are created but have not been issued for incentivizing future employees. And The reason you might do this is that changing this requires an actual amendment. So you might actually, what we call, build headroom into your capital structure. You authorize more shares than you're going to issue so that you can issue more in the future. Again, going back to the corporate purpose, most of the time you put any lawful purpose, and that will avoid an issue we'll talk about in the next video called the ultra vires doctrine. Last but not least is that in addition to the certificate of incorporation, please remember that you'll have to file an annual report, and the annual report has some information that is not on the certificate of incorporation, so you will not be able to keep this information private forever. And your clients may care about this, so there are ways to maintain privacy, for example, of directors, but as you'll see in this slide, on the annual report you will have to state the principal place of the business and the name and address of all the directors who are signing the report. So you'll have to disclose some additional information. Be prepared for that because your clients may or may not want that information disclosed. So be ready for that conversation when it comes. Up next, we're going to talk about the ultra vires doctrine and how to avoid stumbling on it. The ultra vires doctrine, meaning outside of the powers of the company. How do you avoid having actions that go beyond the powers of an incorporated business entity? That's the question for the next video, so we'll see you there.